Imagine losing your life savings in a franchise disaster. As a franchise litigation attorney who's handled over 200 cases, I'll reveal the crucial differences between franchisees and franchisors that can save your investment. Stay tuned for insider secrets that franchisors don't want you to know. If you're considering franchising, whether as a franchisee looking to invest in a business model or as a franchisor wanting to expand your brand, you need to know the ins and outs of franchise agreements. More importantly, you need to spot the red flags before they cost you time and money. As a franchise attorney, I've seen both sides of the equation. Some people thrive while others find themselves trapped in contracts they didn't fully understand. Too many aspiring franchisees jump in without realizing the long-term obligations, and plenty of franchisors can make costly mistakes that lead to disputes. So today we're going to break it all down. We'll talk about the key differences between franchisees and franchisors, the financial commitments involved, and the fine print in franchise agreements, and the warning signs that could make or break your business. By the end, you'll have a clear roadmap to protect yourself and make informed decisions. Let's get started. Who holds the power in a franchise? If you're a franchisee, you're technically a business owner, but there's a catch. You're operating under someone else's brand, and with that comes a set of strict rules. You'll get the advantage of an established name, operational guidance, and marketing support, but you won't have full control over how to run things. You'll be expected to follow the franchisor systems, pay ongoing fees, and maintain brand standards. That doesn't mean you don't have rights. A solid agreement should outline financial obligations up front, define whether you have exclusive territory rights, and clarify whether you can sell or transfer your franchise down the line. One of the biggest red flags is a contract that doesn't give you territorial protection. If your agreement doesn't specify this, you can find yourself competing with another franchise location right next door, or worse, one opened by the franchisor themselves. Now, if you're a franchisor, the one licensing your brand to others, that comes with responsibilities too. You're expected to provide training, ensure consistency across locations, and disclose key financial and legal details before signing on franchisees. But not all franchisors hold up to their end of the deal. If you're considering becoming a franchisee, you need to look into whether the franchisor delivers on the promises. If existing franchisees aren't getting the training or support that were guaranteed, that's a red flag. Understanding the franchise agreement. This is where things get serious. Once you sign a franchise agreement, you're locked in. There's no way out if you realize later that you misread something in the fine print. So before you commit, you need to take a hard look at the financial terms, territory rights, renewal conditions, and dispute resolution process. Franchise fees and royalties are a big piece of the puzzle. Most franchisees require an upfront fee, which can range from tens of thousands of dollars to over $100,000. Beyond that, you'll owe ongoing royalties, typically a percentage of your revenue. Some contracts even require you to pay a minimum amount regardless of sales, which means you could be losing money and still have to pay up. Territory rights are another major factor. Ideally, your contract should grant you exclusive rights to a specific area. Some agreements offer partial protections, but if your contract says nothing about territorial rights, that's a problem. The last thing you want is a competing location opening right next to yours. Then there's the issue of getting out of the contract. Franchise agreements outline renewal terms and termination conditions. Some allow for automatic renewals, while others require you to reapply and pay another fee. And while franchisors have the power to terminate agreements, many contracts don't offer franchisees a clear exit strategy. If the agreement is one-sided, that's a warning sign. If things go south, how disputes are handled matters too. Many agreements require arbitration rather than allowing franchisees to sue. Arbitration is often skewed in favor of the franchisor. If your contract mandates it, understand what you're agreeing to. Next up, how to protect yourself. Before you sign anything, get your hands on the Franchise Disclosure Document, or FDD. This document lays out the franchisor's track record, including any lawsuits, financial performance, and franchise turnover. If a franchisor has a history of legal disputes or a high number of franchisees leaving, take that as a serious warning. You should also hire a franchisee attorney to review your agreements. These contracts can be hundreds of pages long and full of legal jargon, and a lawyer can help you spot potential risks before you sign. Finally, talk to current franchisees. They'll give you real-world perspective on what it's like to operate under the brand. Ask if they're making money, if the franchisor provides the support they promised, and whether they do it all over again. Here's some final thoughts. Franchising can be a fantastic opportunity, but only if you go in with your eyes open. Read your contract carefully. Don't assume it's fair, and pay close attention to financial commitments, territorial rights, and exit strategies. Getting expert legal advice up front could save you from costly mistakes later. If you have any questions about specific franchise agreements or want to dive deeper into the details, feel free to reach out. Best of luck on your franchising journey. Thanks for tuning in, and if you have any questions about this or other legal topics, drop them in the comments below. Don't forget to like, subscribe, and share this video if you found it helpful. Until next time, stay informed and stay protected.